go along to say that the state should adopt regulation?
Lord, our submission is that the international law obligation is that the state is in fact required by its international law obligations and at the international plane to pass legislation for the purposes of the recognition and indeed regulation of Muslim marriages. We submit that is an international law obligation. However, given the manner in which the Constitutional Court in Glenister has dealt with Section 7.2, which is to say this: the state is required to fulfill the rights in the Bill of Rights and to act reasonably in doing so. The Commission for Gender Equality has explained this, I submit, very clearly. Now, our submission in relation to prayers 4 and 5 is this: it would be unreasonable for the state to act in a manner in seeking to fulfill the rights in the Bill of Rights that is contrary to South Africa's international law obligations. Given that South Africa's international law obligations include an obligation to promulgate legislation, it would be unreasonable and therefore not in compliance with Section 7.2 of the Constitution for the state not to promulgate that legislation.
Can you just get your ultimate proposition? Because I think that's what we're now interested in, and what the argument of the entire
Yes.
case. Yes. Because your heads seem to be devoted mainly to prayer 6.
They are.
And so your conclusion would be that you agree that there should be legislation, but you're saying that the state, if I read 103, paragraph 103 of your heads, in conclusion, while the state is yet to comply with its far reaching positive international obligations to regulate the consequence of Muslim marriages by means of the regulation of the legislation, it has evinced its intention to do so and has taken steps towards the achievement of this complex and onerous task. The Human Rights Commission, therefore, submits that the declaratory order in the form of prayer 6 of the amended notice of motion is not warranted. I thought that that was your case.
Indeed so, milady. Very clearly, a declaratory order in the form of prayer 6 is inappropriate. We covered that in our heads of argument.
But you don't really mention other things.
We do say elsewhere in our heads that we broadly support the relief sought by the Women's Legal Centre, and that would fundamentally be prayers 4 and 5. And we are not going to enter into the question of prayer 7. That's a factual matter that the parties are going to have to debate on the papers. But prayers 4 and 5, and this is perhaps a matter that may not have emerged with the greatest level of clarity from anybody's heads in this matter, I submit. The international law obligations infuse the domestic obligation under Section 7.2 of the Constitution. As we move forward in this matter, I implore the Court that to pay very, very careful attention to paragraphs 189 to 202 of the Glenister 2 judgment. Because what we see there is that, as the Court pleases, yes. And I think that the Court, obviously, and the Constitutional Court ultimately did approve of the order, but the mechanism by which international law is, in the words of the Constitutional Court, brought to the very heart of our constitutional obligations through the operation of Section 7.2 and the reasonableness requirement that is set out in that section imports, is a very important part of this case, as I say, which is going to form the subject matter of our oral submission. But when it comes to prayer 6, we certainly don't support that.
Thank you. We'll give back to Ms. Barbara. So you understand that in this case, as we asked them in the principle, what is your attitude? You said,
our attitude is as set out in our heads of argument, which is we don't support any of the reliefs. As we've read the amended notice of motion, I'm telling you, there is a cell phone that is going off, which is really distracting, and I have no idea what's happening. Lord, I'll speak about it, but it's amended relief paragraph 4 that seeks a declarator that the first respondent has failed various duties. Obviously, we resist that. In paragraph 5 is declaring that the Parliament has failed various duties. I understand that that is opposed by Parliament as well. And then paragraph 6 it deals with the declaration of the failure to promulgate an act of Parliament. From the first respondent's perspective, we also oppose such a declarator. And then follow the directive orders. Now, Malona, I understood your question to be, does any of the parties have an objection to a declarator that Muslim marriages are valid?
Or
It would appear that it's in my very own handbag and I apologize.
maybe it's the first person that I haven't seen this
Sorry, Lord. I understood that I had switched it off.
I thought the believers was a good party.
You cast the stone, the first stone. It's a great lesson for us. The question as to whether anyone has an objection to a declarative to the effect that Muslim marriages are generally recognizable, that is something I would need to apply my mind to, because as we understand the effect of the Marriage Act, it is to allow for the secular recognition of Muslim marriages. So that is something we would need to think about some more. That is our
You
position.
see, I would like to avoid the ghastly consequence of the past that Muslim marriages are illegal. That's the notion. That Islam is one of the 6 major religions of the world now. We don't want it to be in this country that I'm sure your client would want that sort of consequence. Clear and unequivocal account of the effect.
And so decisive break with common law.
The consequences we can talk to much now about the consequences. That's the next thing.
Is your argument not such that there will be the way of future, that at this point that it is premature, given the fact that consultation with the community has not been exhausted? That's been 20 years on.
It has. It depends on how we cast the chronology. If we could take it 400 years back, or we could take it 20 years back. But it is something we would like to think about, certainly from the notion that any form of marriage, any form of religious marriage, being unlawful is anathema. It's certainly anathema in this day and age, providing, of course, that the rest of the Bill of Rights balances out. But broadly speaking, may we have more time to think
Yes,
about?
please think about that.
Yes.
Perhaps we really need to consult.
Yes.
We have
Thank
2
you.
weeks to go through all of this.
Certainly we can say that that whole outdated common law perception that Muslim marriages are contra bonus lawyers has no place in our
That's the point we want to
Yes.
avoid,
Yes.
and we have the fortunate consequence of sitting as a full court.
Yes.
So we make an unequivocal statement to the effects.
As I say, the ladies and the lords, it is something we need to think about,
Consequences we
but
can
that
in this
is,
debate this time. We can go.
yes.
Thank you very much, Mr. Chair. You'll address us further. Anybody else wishes to comment on that?
Please, yes, my lord, yes. Very eager. My lord, what we should be cautious about is not subverting the law. Now, a declaratory order number 1 is not being asked. More specifically, there is no prayer for this court to declare Muslim marriages in Vakwa to be lawful, firstly.
What you say is no premise for that.
There's no prayer. And then, my lord,
No, but she says opening to recognize Muslim marriages.
Chief Justice Mohammed has done this in Ahmad case, in a host of judgments following, where our courts have recognized Muslim marriage on an ad hoc basis, giving relief for inheritance, giving a host and of wide-ranging relief. But I respectfully say, my lord, to make an order to say that Muslim marriages are recognized, a declarative, when it is already so, will amount to brutal involvement. Then, my lord, Section 7.2 of the Constitution, let's analyze it. Judge Cameron, in this case in the Constitutional Court, he said this tongue in cheek and it's all.
Mr. Kumar, what is your objection to declare it to simply to the effect Muslim marriage is legal, it's done, not, may not even be for any purposes of the law, but purposes simply of history. That historically there's been an attempt to compromise people married by Muslim law by declaring the marriages unlawful conduct of against contrabandist law, etc.
With respect, my lord. Late Chief Justice,
How does it impact on what you want to achieve if you object to that?
late Chief Justice Mohammed, I recollect Advocate Panado on this issue.
He dealt with it.
He extensively, I mean, he raked his brains. Late Dana Umar Makim Jannah too.
There's no harm in repeating that to the people, especially in this division where Islam for so long people that declare legal full stop.
My lord, in the annals of history, what will go down is the following. And the media, the DA media, President Zuma failed to recognize Muslim marriages in 20, no, with respect. My lord, what I'm saying is, the fact of the matter is today in South Africa, Muslim marriages are lawful. There's Chief Justice Mohammed went backwards to emphasize this first. Secondly, what is the obstacle to this court declaring an order? This is the obstacle. The law on declarative is the following, my lord. All interested parties should be joined in an application for declaration of rights. The reason for this is that the rule that a declarative cannot affect the rights of persons who are not parties to the proceedings. I'm submitting with respect. We can't take the law regulating declaratory orders and turn it on its head. There's no relief sought. There's no party affected.
In the relief sort, the whole line of cases that start with acts versus agreements 100 years ago. You say you can't order the character unless there's consequential relief.
My lord,
And now,
the apparent,
there's honest.
it appears, this issue appears to be vexed to the court, but not to me. I submit with respect. Chief Justice Mohammed dealt with this in armored and unequivocally stated it. But then, my lord, on the issue of the Human Rights Commission, my lord, Judge Cameron, in the Constitutional Court, in his judgment, identifies between preparation, initiation, and enactment of legislation. Section 72 talks of the state shall respect and protect rights. The Human Rights Commission and the Gender Commission of Equality are Chapter 9 institutions. It is them who are mandated to investigate the issues raised by Chief Justice Mohammed. It's the duty and the function of the Human Rights Commission to have investigated, used its resources, and then present a case for the initiation of legislation. But for the Human Rights Commission to abdicate its functions and duties imposed by the Constitution and the gender equality.
You can deal with that when he presents his argument. This is just the issue I raised in the beginning. We were trying to clarify our own thoughts.
Naturally. So in summary, Judge, what I'm saying is, one, we do in fact resist a declaratory order which, if pronounced,
You can argue that later.
the law is Muslim marriage are recognized. And the other issue is the Human Rights Commission and Gender Commission have an obligation to investigate this. Thank you, my lord.
Thank you.
Maybe perhaps,
Oh, yes.
yes. But Lord, as I understand it, the declarative would mean that the marriage is valid, and that has been done in Ryland and Idris's case to some extent, but it would be useful, we would submit that the full bench confirms the result. That doesn't mean
That
that our
also
case...
states it unequivocally.
Yes, no, quite, my lord. That doesn't mean it's a marriage as envisaged in the Marriage Act. The consequence is that is what our case is like. But certainly it would be useful.
But so as to avoid the negative influences
Yes,
of
right.
marriages is not legal.
And I don't think such a declarative has ever been granted to the ladies.
That's the point.
Ryland and Idris recognized the contract and as such walked away from Ishmael.
Comes to some extent to stating it didn't quite state.
Yes.
We like this. And we'll look at the law on that as the situation.
Well, let me just add to what I said earlier, having had the benefit of this further thought on the issue. With respect, apart from the fact that there's no prayer for such relief, even if we were to consider that perhaps the relief would be extended to accommodate that particular question, the fundamental objection that we would have to